Management 203 class. Today we're going to be talking about Chapter 10, which is all about grievances. If you will remember, there are two things that union dues can always be used for, and that's collective bargaining and grievances. Anytime a union employee has a problem with a company, one of the big perks of being a member of the labor union is having somebody who will stand with you in your grievance process. So we're going to talk about what a grievance is. A grievance basically is any time somebody believes something isn't working well in the work environment. It could be something involving the collective bargaining agreement, or it could be somebody's just annoyed at work, unhappy with the way things are. I don't like the way the supervisor is treating me. Generally speaking, better managed companies have less frivolous grievances, but people are people, and sometimes human beings just want to be heard. So a grievance is any time somebody has a problem with the working conditions of a company. And we can have grievances in union or non-union companies. And non-union companies are generally not as well defined of a process for being able to deal with grievances, however. So in terms of the way grievance forms should be filled out, these are usually in paper or online, but essentially somebody is documenting their complaint. This is a great example from our text. The foreman is against me. He always has it in for me. Lots of times he gives me 30 jobs. Now he refuses to give me holiday pay. Basically, it comes down to somebody wanting to complain, making very vague complaints, things that are really hard to quantify and hard for somebody at the union side or at the committee side even to be able to process. And we go to the proper way a grievance report should be filled. I, the undersigned, a laborer in the melt department, claimed the company violated Section 10, holidays of the basic agreement. So we're talking about somebody who obviously knows the terms of their collective bargaining agreement. A lot of the times, if we have rank and file, people who are represented by unions, sometimes they don't know the letter of their own collective bargaining agreement, and that's how we get a lot of grievances that really are without merit, for example. So in terms of written grievances, you can have written or spoken, but the advantage is you got a record of it. I am going on record and I'm putting it down to say in writing, I have a problem with this area. I have a problem with this aspect. I have a problem with this part of the collective bargaining agreement. What this comes down to, too, is you get a chance to separate yourself. Let's think about it. If you have a chance to have a conversation when you're really fired up versus a chance to walk away and write it down, which are you more likely to have a more measured response? If we have a cool down period and we're forced to reflect on our own thoughts and writing, sometimes these things are more rational, less emotional, and they also provide more specifics. One of the other advantages to management on this is if you have a written requirement for grievances, you tend to have fewer grievances because when somebody finds out they have to put it in writing, that they have a complaint, oftentimes people will decide they don't want to bother. Either it's too much work or they have the time to really think about it. So again, written grievances help companies to make the process more manageable as well. So we have a couple of approaches that we can think about here. One is called a therapeutic approach, and that means we're basically using these grievances to make the work better, to make our environment better. And if we're addressing every single grievance, we're not, as a company, really thinking so much about the collective bargaining agreement, but thinking about the well-being of our employees, for example. That's opposed to the legalistic approach, which means when somebody's filing a grievance, for example, they think that we're in a situation where their rights have been compromised under the collective bargaining agreement, and so the idea is that they're filing this grievance in an attempt for restitution or to be treated within the terms of their collective bargaining agreement. So there's therapeutic and legalistic approaches to this. Legalistic basically means you're talking specifically about the collective bargaining agreement. So what are some of the subjects that might be grievances? Well, if it's administrative issues, did somebody stiff me in seniority? Have I been here longer than somebody else, and did somebody bid for a job that I thought I was able to get? What about the safety of the organization? Am I not getting training? Anything administratively in terms of developing people? Economic issues are big ones too. Am I not getting paid what I'm supposed to be getting paid? Am I not getting opportunities for overtime? Am I not getting opportunities for shift differentials or merit pay, for example? Then we get into employee discipline, meaning, did somebody break the rules of the work environment, the conditions of work? Was somebody punished by management under the conditions of work? Were you asked to do something that was illegal? Were you asked to do something that was immoral? Were you sexually harassed by your supervisor? The flip side is, am I being punished because my fellow employees are showing up late at work? Are they causing a hostile work environment? So we get into employee discipline as well. So administrative are issues involving things like seniority and safety and health. Economic issues is all about wages. Employee discipline is all about behavioral issues. These are all subject matter for grievances. So who files? If you have people who are filing grievances, the younger the person, the more likely they're going to file a grievance. Here's why. People who have been with a company and a member of a labor union for a long time have seen things come and go. They know how things work, what's likely to get a response, what's likely to not get a response. So generally speaking, it has to be a pretty serious issue for somebody who's an older, more experienced member of the union. And people who are not actively involved with the union sometimes are less likely to file too. To be blunt, many of these individuals may not even realize they have certain rights under their own collective bargaining agreement. Why do people file? Well, sometimes people are upset about a legitimate violation. It could be something that's not happening or should be happening based on the terms of the collective bargaining agreement. There may be a safety issue that somebody wants to draw attention to. They may also do it just to make the union look big. We're going to file this grievance because we can. There are unethical people too who try to make charges that are false in the hopes that they're going to get something like overtime pay or reinstatement, things that maybe they're not entitled to, but they use the grievance process to try to get things to which they are not entitled. So what about grievances on non-union firms? We've got lots of companies who have employee committees and internal committees and things that appear on paper to be company-run unions. So we can have a grievance procedure. A non-union company will have a grievance procedure too. The difference is that the grievance procedure in a non-union company is dictated based on what the company has said is the procedure. So it's not something that was negotiated by the company and the union. What can happen here is if people are having problems with the company and there's lots of grievances filed, this sometimes can spur unionization. So sometimes grievances not getting resolved will cause a union to have cause to come into an employer and to have the momentum to actually come in. Now, in terms of the effect of grievances on union firms, it comes down to, it depends how long you've been unionized. Most unionized companies are pretty used to this stuff. It gives unions a chance to deal with things that maybe were not completely spelled out in the collective bargaining agreement. You know, if there are things that fell through the cracks in the contract. It also makes sure that we have a structural way for labor and management to talk. So in union firms, grievance procedures are not only standard and not only familiar to these folks, they actually can be really helpful in terms of their operation. Here's a basic idea. For example, if you wanted to gather evidence for grievance, if we were getting into a situation where we actually had to head into arbitration between a union and an employer because things had gotten so bad, obviously, people on both sides are going to want to find out what really happened here. Back up the facts, back up these points with evidence. We're going to assess that stuff to see, are people telling the truth? Or multiple people, for example, saying, yes, we've observed that there's an unsafe labor practice happening in our company. You would frame your arguments. For example, if the employee / the union wanted to frame that an individual were being singled out, they would want to be able to frame the argument to point that out. The company might want to be able to frame their argument that we're backing up standard operating procedures in terms of collective bargaining agreement. Once we get into discussion and arbitration, we basically want to try to find some things that we can agree upon. We agree that the following things happen. We agree that the following things are rules for our work environment. We disagree on what we believe to be the issues at hand, for example. At that point, you would get your witnesses together to talk about what they had seen and get ready to talk about the admissibility of evidence and defenses. It is like a mini court approach, but if you're getting into binding arbitration, the outcome of this issue could affect all parties. So what's information the union might request in this procedure? Well, yeah, if you've got videotapes of the work environment, if you've got violations that have been on record, if you've got accident records, any records that would document the employee's potential concerns and how these issues might have affected that individual could be information the union might want to be able to prepare their argument as well. So here's an example of how we might walk through a typical grievance procedure. With the first step in the process, we've got an employee who's experienced something they believe is eligible to be a grievance. The first thing they do is to file the grievance. You can do it verbally or in writing, depending on the norms at the institution where they work. And if they're doing this in writing or verbally, they can have a union rep with them, or they can do it by themselves. So every individual collective bargaining agreement will have its own terms in terms of limitations, statute of limitations through which you would file a grievance. The first step might be, for example, we're going to meet within the next 15 days to try to figure this out with the person who was involved from management. In this case, for this example, was a first-line supervisor. If we're able to figure it out, come to a conclusion, it could be something as simple as soothing some hurt feelings. Maybe we're done. If not, if it's unresolved, we go to writing and we move up the management chain. Management provides an answer, and at that point, if the union person is not satisfied with the answer, if that person does not believe that answer, that their grievance has been resolved, we move on to the next step. At that point, we have a union grievance committee, which means the person who had filed the grievance is now joined by several other members of the labor union who are going to help this person figure it out. And they have a meeting to discuss this stuff. Then we go back to the plant. You see what's happening here, guys, is as we move through this process, the further up the chain, the more people get involved, the more formal it becomes. And again, these people caucus, they meet, they talk, and if management comes back with a solution, and if it's resolved, it could be something as simple as, well, this person will get an extra day off to make up for the day we made them work, which was outside the terms of the collective bargaining agreement. All's well and good. If not, we have a period for response, and we go on up the chain to management. And then finally, we move on up. If this continues, if this process continues, we might end up in arbitration or mediation. And we end up then finally with a resolution through a third-party neutral arbitrator. If it gets that big, we've got to have somebody come in and give us binding arbitration. Then our grievance process has probably internally not worked, or the problem has been that egregious. So in terms of different approaches that we can take, we have transformative or collaborative mediation, we have evaluative, and we've got direct results-oriented mediation. So in terms of grievance arbitration versus mediation, we obviously know that if you have a mediator versus an arbitrator, arbitrators, for example, generally have binding decisions where mediators try to facilitate conversation. So if we get into transformation or collaborative mediation, it means that we're trying to get people to work together and really understand where the other person is coming from. Oh, you don't like mandated overtime, employee. We understand where that can mess with your schedule, as opposed to coming in and really being confrontational about the discussion. The evaluated mediation, instead of trying to facilitate conversation, the mediator just comes in and basically lets people start talking about where they're at from the position and tries to find some sort of way to work those two folks together. So in the transformation or collaborative approach, we're doing more hands-on. We're trying to soothe things a little more than we are in evaluative. So in direct or results-oriented mediation, we're trying to get to the root of the problem and resolve it. What are the actual issues? What's it going to take to solve this? And it means that we're meeting separately with each party, with labor and management, to try to actually find out, instead of conversationally. It's kind of like saying, well, you tell this person I said this. You tell this person I said that. It's less interactive between the parties, and it's a little bit more cold and informal. So why don't we use mediation more often than arbitration? As we've discussed in previous chapters, a lot of folks don't like the idea of having to compromise, having to give up something, having to look weak. If I'm willing to give in and have a conversation, I'm admitting I might be wrong on something. It's not really much different than conversations between friends who are trying to save face, or spouses for that matter. But it's something that doesn't get used more often for very interpersonal and very psychological reasons. So what are other kinds of alternative dispute resolution procedures that we might have? Well, then we've got something called open door policy, which means that you're encouraging employees to come see you whenever they are having issues, for example. And instead of letting this fester, instead of filing a grievance, I'm your manager, come sit in my office, let's talk about it, let's see what the issue is. This is something that's also very interesting too. We're seeing this in even non-union environments. The researchman has something called ombudsperson. We used to call them ombudsmen, but they're ombudsperson now. And that's a person who basically serves as a neutral mediator. could be somebody who works within your company, could be a member of the labor unit who is willing to have facilitated conversations between labor and management in a more informal sense. We're seeing this actually occur in white-collar environments, even in places like education now. It's becoming very popular to have folks who are a little less formal, kind of like an internal mediator, instead of going formal with it. We also have what we refer to as peer review systems. You may see these more frequently in non-union companies. The idea that we're going to have internal company committees who are going to review these complaints and try to come to some solution. And then we also have something called early neutral evaluation, which means we maybe have non-binding arbitration, which means somebody comes in and gives us their outside opinion. Maybe we have a legal counsel, for example, who comes in and listens to both sides to offer these kinds of inputs. All of these things, all these kinds of ADR work best when you've got good relationships between the company and the employees. So in terms of relationships and flexibility, we've got a couple of areas to talk about. We've got what we refer to as codified relationships, power relationships, and empathetic relationships. Codified relationships means, on paper, who do you report to? Are you a member of the bargaining unit? Are you a member of the company administration? Power relationships apply to where you fall in the management chain. Are you above or below somebody? And empathetic relationships mean, how do we like somebody or not? There are plenty of people who work for labor or for management who go across company lines as friends. They like each other. And that's a good thing, because it means when we get into these kinds of grievances, maybe we can figure this out like human beings instead of just by the terms of our contract or agreement. So we also have something called the third and one-half step. This is essentially a way that union and management get together and talk about what's eating each other about each other. If you've ever watched Seinfeld and heard of Festivus, they have the airing of grievances. This is kind of like the idea of figuring things out with open dialogue and open conversation. We call it the third and one-half step rule. So if there's a time when labor management can get together and really hash it out in an open form, we call it the rule of third and one-half step. Then we've got what we refer to as the duty of fair representation. And here's what this means, guys. If you are paying union dues and you are a member of a labor union, you are entitled to equal representation with all your union brothers and sisters. That means that your union cannot show you preferential treatment, and they also can't kick you to the curb. You may say to yourself, well, that's really tough, because you might have some people in the labor union who are great performers and some folks who are not good performers, people who ride other people's coattails. And it's true, and it's one of the pitfalls of labor unions, because you've got to back up the good with the bad. And it means that, for example, if you are a union and you fail to represent one of your members because you don't like them or feel that they represent poorly on you, you can be putting yourself in a precarious legal situation. So in terms of jurisdiction, when we get into fair representation claims, if somebody feels they have not been fairly represented by their union, it starts by going to a district court. And an employee who feels that their union has thrown them away, has not represented them well, they can take their union to court and have a jury trial, try to get back pay. There's a famous court case called Veka versus Stipes, and here's what basically it came down to. If there's a breach of a relationship, or fair representation between the union and the employee has to prove it. The union, however, has basically come out on the side of this, the courts have come out on the side of this, that the union doesn't have to take an employee's grievance the whole way to arbitration. It comes down to whatever the union's obligation is. So in other words, the union is not required to go the whole way to the wall for you if it's not really their responsibility. It's not something that's been agreed to in the terms of the collective bargaining agreement. So the golden rules of union seven golden rules on the union's duty of fair representation come down to as follows. You got to look at things on their face. You've got to treat people with respect. You've got to stick within your time limits and have a valid reason for all the things you're doing. In other words, you got to keep good records. You got to treat people fairly. You got to go through the process and the timeline that you said you would, and treat all people as part of the process equally. So in terms of breaches, we have what's referred to as perfunctory conduct by the union. And what that means is if you have somebody's going through the grievance process and you're not defending them like you would somebody else, or under the terms of your collective bargaining agreement, or if you are screwing around with timing, if you are not backing up your own terms of the collective bargaining agreement on things like seniority or keeping somebody informed in terms of what's going on with their case, you could be breaching your own contract with your own union member. And this does happen. Bowen versus United States Postal Service, basically we had a person from the USPS who had been improperly dismissed. The union did not do a good job representing that person, and the court basically said that the union messed up. They did not properly represent this person. So the company basically was liable for back wages, but only until the point where the union quit doing its job. From that point, so in other words, let's say this person was going through arbitration, and the union was backing this person up, and they should not have been terminated. The company's liable up to the point where the union screwed up. The union screwed up and quit representing this person well, and as a result, from that point on, from the point where it was determined that the union had not lived up to their responsibility, the back wages at that point were the responsibility of the union. So the unions could be responsible for this stuff too. So, we see this kind of spelled out here in terms of where the point in company responsibility and union responsibility with the union is stopping what they're doing. And we see in this case, the union decides not to appeal the grievance to arbitration. From the point the grievance says, I'm going to sue the union for not representing me, at that point, if that plaintiff wins, the union's responsible for any wages that person would have been entitled to from then on. Guys, thanks very much. I look forward to hearing from you, and I hope you enjoyed this presentation.